testified in committee that he had done that as a matter of practice earlier in his career. So some people do file recordations, and however it's being titled right now, I assume that's the process by which they continue to use.
Senator from Stafford County, Senator Stewart.
Further question, Mr. President?
Senator has the floor.
I yield.
I'm not sure that I'm explaining myself to the gentleman, Mr. President, very well. We've got to give notice. We've heard testimony today about chain of title and notice on the floor today. How do we give notice to subsequent purchasers of property that there's a note out there somebody else owns without referencing it to the original security instrument? Have you explored that with the clerks as to how you intend to accomplish that with this measure?
Senator from Fairfax City, Senator Peterson.
Again, Mr. President, to answer the gentleman, I spoke to my Fairfax County Clerk of Court and how they do it. What my understanding is, a deed of trust obviously is going to be placed in land records. It'll be filed in land records. And to me, to the extent that the underlying note is bought and sold within that deed of trust, I assume you would just staple it or attach it or however you do that electronically to that deed of trust. That would be my understanding. But again, I'm not a professional in this field.
Further question, Mr. President?
Senator has the floor.
The gentleman yield for another question, Mr.
I
President?
yield.
He yields.
As I read this, Mr. President, on line 117 through 119, do I understand that the failure to record this, or is it the failure to tie it back to the original security instrument, invalidates the assignment?
Senator from Fairfax City, Senator Peterson.
Well, I'd say to the gentleman, as in every transaction, you can always go back and backdate where you have consenting parties, so I don't think it would. I mean, again, where you have consenting parties, you can go and backdate a document.
Senator from Stafford County, Senator Stewart.
Thank you, Mr. President. Mr. President, I would ask the gentleman again, line 117, it says effective July 1, 2011, recordation of the certificate of the assignment as required by subsection A as necessary in order to transfer and assignee the benefit of the security provided by the deed of trust, mortgage, or vendor's lien. If it doesn't happen, or if it's not found, does that invalidate the security instrument?
Senator from Fairfax City, Senator
I'd
Peterson.
answer the gentleman as follows, and that is, let's say you sell a mortgage note to a third party, and subsequently you're holding that mortgage note, and the person then defaults on the underlying mortgage. And let's say you now want to foreclose, and you had forgotten to record that interest. I think you'd have to go back to the person that sold you the mortgage and say, I didn't record this assignment, and record it contemporaneously at that time. And I think that would be the situation you'd be left in. I don't think you're completely out of luck, but at some point you're going to have to record that instrument.
Senator from Stafford County, Senator Stewart.
I thank the gentleman, Mr. President. Speaking to the measure.
Senator has the floor.
Mr. President, I would just tell the body that I thought this was a good idea until I read this bill and read it thoroughly, and that's what caused me to not support it. Giving transparency, obviously we all want to do that. Right now, the borrower gets the notice. The borrower knows who holds that note. At least they're required to by existing law. And while I applaud the gentleman for what he attempts to do here, it creates problems within the system. It creates unintended consequences that, quite frankly, concern me. I've done a little bit of this dirt law work that they referred to on the floor, and title exams are complicated enough without adding additional responsibilities to clerks. We haven't even talked about the fee. The fact is, if this note is sold, somebody's got to pay the fee to record this. They've got to figure out a way for the clerk to manually go back and index this to the original security instrument. It's a lot of work for the clerk, and banks, quite frankly, are going to price these transfer fees into the original loan, and I'm not sure how they do it, so it's going to raise the cost of credit for consumers. So something that is intended to benefit consumers at the end of the day, I fear is going to harm them.
Thank you, Senator. The Senator from Roanoke City, Senator Edwards.
Mr. President, speaking to the bill, this bill was heard in the Civil Law Subcommittee for a period of time, and then in an unusual situation, we heard it again with the witnesses before the Courts of Justice Committee, and both sides had a chance to, however many sides there are on this, had a chance to say their piece. One of the things that quite honestly persuaded me was that the Virginia Bar Association real estate section, consisting of lawyers who represent lenders, they represent borrowers, they represent real estate development interests, they represent a variety of interests involving the real estate industry. I guess it was unanimous, but in any event, they strongly supported this bill. And they're the ones that have to deal with the legal complexities involving real estate transactions. We do know that the banking industry has evolved in recent years to the point where mortgages are wholesaled out, sometimes more than once, to the point where the people involved in the transactions don't always know readily who the owner of the debt is. We do know, too, that in what happened a couple of years ago with regard to the national economy had to do with subprime loans being bundled and sold on Wall Street, and then insurance companies issuing derivatives. It was so complicated, nobody could understand it or explain it. And that had a lot to do with the collapse of Wall Street. All this is a little more transparency. This simply says whoever owns the note should have that recorded in the clerk's office. And that would aid all the interested parties in terms of organizing their transaction, contacting the note holder, finding out whether or not the mortgage could be modified. We heard testimony that in the process of trying to modify a mortgage, the house was foreclosed on and sold out before the modification could go through. In other words, the right hand didn't seem to know what the left hand was doing. And so based on the testimony we heard, I would hope this body would agree to go ahead and pass this good bill. Thank you, Mr. President.
Senator from Richmond City, Senator Marsh.
Mr. President, the senator from Roanoke made the points that I wanted to make. This bill was thoroughly heard before the committee. The same arguments that we're hearing against the bill here today were heard before the committee, and it was soundly rejected. Even the opponents of this bill say that the situation isn't working. We have problems. And as I said, if you keep on doing the same thing the same way, you're going to get the same result. Many people are being hurt because they don't know who's holding the loan. And I think this bill goes a long ways to curing it. It's not going to hurt any bank that's doing business in a legitimate way. So I urge you to support the bill.
Thanks, Senator. Senator from Prince William, Senator Colgan.
Mr. President, I move the pending question.
Senator, there are no additional speakers, Senator. You've done it about 45 minutes ago. The question is, shall the pending question be ordered? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators require to change their votes? The clerk will close the roll.
Ayes 32, noes 8.
Ayes 32, noes 8. The pending question is ordered. The pending question is, shall the bill pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their votes? The clerk will close the roll.
Ayes 14, noes 26.
Ayes 14, noes 26. The bill fails to pass.
Senate Bill 8.